coming in from Karnataka as the state's High Court has now announced its verdict on X's plea that was, remember, challenging the centre's power under the IT Act to issue blocking orders. The High Court said that Sahyog portal is for public good. It's a mechanism through which state now aims to combat cybercrime. The court has also added that no social media platform shall consider Indian market as merely a playground. We are a society governed by laws. A very significant verdict coming in from the Karnataka High Court. Remember, X had challenged centre's power under the IT Act to issue any kind of blocking orders. Let's quickly go across to Ananya Bhatnagar, who brings us those breaking inputs. A very significant verdict, Ananya, because remember, the control over big tech, particularly in a democracy as huge as India, has been debated for quite a while now.
Absolutely. It's a clear order coming in from the Karnataka High Court, and a big one coming in favor of the central government's Sahyog portal, wherein not only the constitutionality of the Sahyog portal has been upheld by a single judge bench of Justice M. Nagaprasanna, but also, in fact, has been stated that all of these big players, all these big social media platforms cannot treat India as merely a market or as a playground, Indian market as a playground. And this is a society that is run by laws, and they will have to abide by these laws. Not only that, it also goes on to say that the petition that was filed by X Corp, or probably known as Twitter Incorporated, is something that seems to be meritless because it is not an Indian citizen, and it cannot claim the right of Article 19(1). And even, the Article 19(1), which provides the right to free speech and expression, is also having certain restrictions under Article 19(2). In fact, the Sahyog portal has been given a good word by the Karnataka High Court, saying that it seems to bridge the gap for the citizens. That is something that's been brought by the government in order to fight cybercrime. It would act as an instrument to fight cybercrime. So big order coming in from the Karnataka High Court for, in fact, the central government. Whether the Twitter would be challenging this, X Corp would be challenging this particular order before the higher benches or before the Supreme Court is something that we'll have to wait.
Right. Ananya, if you could also take our viewers through what Section 79 was stating, because remember, that is exactly what X has challenged as far as government's use of this particular section is concerned. What was it that led to this entire lawsuit?
Well, Section 79 basically deals with the government's power to issue blocking orders in order to block certain content on, these social media platforms, including X Corp. And that is something, that power had been challenged by, in fact, X Corp primarily, and also the induction on the Sahyog portal was something that was challenged by X Corp, but both of them have now been held to be constitutional in nature. The Karnataka High Court very well going on to say that, it is something that is mandatory, and information since the very inception has never gone unchecked, whether it's the postal era or the age of Snapchat or WhatsApp or, the current social media platforms. The information and its dissemination has never gone unchecked. We have had laws in the country, whether it's the IT Act, whether it's the Article 19(1) or 2 of the Constitution of India. Information has always been, the freedom of speech and expression has always been balanced with reasonable restrictions as well.
Ananya, why is Sahyog portal so critical to this case right now, and the powers granted, which of course have been upheld by the Karnataka High Court as well?
Well, the government had introduced the Sahyog portal so that the social media platforms and, in fact, the center could have, the government could actually have certain kind of a platform where, if at all there is a content that is defamatory or something that is problematic, or certain information needed to be sought by the government in order to tackle or get cybercrime under its lens, then this portal could have acted as something that is very, very important. Registration of Sahyog portal was something that was mandated under the IT rules that were brought in by the central government by way of a legislation. And this was something that the government had been promoting for a long while. And now, finally, a constitutional stamp, a stamp from the High Court on the constitutionality of this portal, and also, in fact, a big win coming in for the central government from the Karnataka High Court single judge bench for the central government as well.
So, are we to now believe that the IT Act is the sole charge when it comes to content moderation and ordering of any removal of content online, whether it is X or any other social media platform?
Well, absolutely. There is a certain kind of a restriction as far as the freedom of speech and expression is concerned. And all these social media platforms need to comply with the laws of the land is what, in fact, the pitch that is coming in from the Karnataka High Court very clearly going on to say that these big social media platforms cannot just consider India to be a marketplace, Indian marketplace to be a playground. And there is something called the laws which we are governed by, and this society is governed by laws, and hence these laws need to be followed by these big social media corporations as well.
Will this also now, my last question, Ananya, control the powers of the AI chatbot Grok 3 on X?
Well, that is something, that we'll have to go deeper into the judgment to understand, but the detailed judgment copy would be out tomorrow itself. But the major powers and the major restrictions that Twitter had challenged, those come to be very, very constitutional in nature. And that has now been stamped, those powers of the central government to issue blocking orders, or whether, the whole IT Act is concerned. These are certain powers that had been challenged, and that is something that has been said to be constitutional by the Karnataka High Court single judge bench itself. But it's a significant order when
Yes, how Grok, in fact, moves ahead, given that it was being criticized for being critical of the government. We'll have to see if the powers are now going to be taken back. Many thanks to you, Ananya, for bringing us those detailed inputs on that news story. With that, we're slipping into a quick break.